Good morning. My name is Cormac Butler. In the UK, I was involved as a consultant in regulating banks. And obviously, during the banking crisis, we discovered quite a lot of problems. And I'd like to reveal some of those to you today because they have a very important impact on the message that Theo McDonald has given. So I'll start with some of the practical problems we face. When we go to court defending borrowers in a case, for the convenience of the vulture funds and for the convenience of the banks, that's often classified as a summary hearing. And what that simply means is the vulture fund turns up with land registry records to say that they're the legal owners. They then show that there are statements that the loan has gone into default, and therefore they're entitled to get possession of the property. It's that simple. But there are a number of practical problems. So one of the first things anyone in front of a court should be trying to do is to convert the case from a summary case to a plenary case, because with the plenary case, we have the advantage of putting the original bank under cross-examination. Why is that important? There are a number of unfair terms in loan contracts drawn since 2004. In particular, there is a question whether the bank can recover the full principal outstanding when they are responsible for some of the losses that the customers have suffered. There's also a problem with the interest rate. Many loans are on a variable interest rate, which, according to the banks, are discretionary, which means that they can push up interest rates if they wish without your approval. And that's known in legal terms as a potential plug on redemption. It's also unfair under the Unfair Terms Act. Judges are required to consider these in own motion obligations. Very few of them do, particularly in summary proceedings. However, if the case was transferred to plenary proceedings, you would be entitled to examine the original bank, ask them to turn up as witnesses in court and explain why there are some unfair terms in their loan contracts. This is the major elephant in the room. It was a schedule put together in around 2015 concerning all the major banks in Ireland and the UK. If the figure on the last column is above 100%, then the bank was technically bankrupt or insolvent. And that has two important implications. In fact, it has three important implications, which you should try to refer to if you are brought up to court. The first is, if you were a bank and you had this schedule in front of you in 2004, would you lend to a customer? Or if you were a customer, would you borrow? And the answer to both questions should be no. You shouldn't lend and the customer shouldn't borrow, because this is the precursor to a huge crash that is coming. Banks were hiding losses, as we all know. They claimed it was legal to do so, but they still hid losses. And when you hide losses, to the level that these banks have been doing. Look at the figures at the end. In Ireland, it was 47 billion, and in the UK, it was 98 billion pounds. So 47 billion euro and 98 billion pounds. Clearly, there was a banking crisis on its way, and clearly, any asset that was dependent on credit was going to devalue and suffer. You, the customer, was not aware of that, but the banks were aware. And there is case law to state that if the banks get involved in contributory negligence, if they fail to comply with the law, and in this case they fail to comply with the solvency rules, the question you have to ask is, would they have lent you money if they decided to comply with the law? And the answer would have to be no, because these loans were impaired to begin with. They were unrecoverable on the date that they were advanced. So banks suffered substantial losses. Theo has mentioned this in his report. He's given quite a detailed background to this, so it's worth reading because it is quite important, and it can be raised in court, particularly at a plenary hearing. The second issue is the interest rate. Some banks charge cost of funds. What happens if you're an insolvent bank trying to borrow money? The chances are you're forced, either you're unable to borrow, or if you can borrow illegally, you're going to pay an extortionate rate of interest. Under the current interest rate clauses, the bank is potentially allowed to pass on that increased cost to you, the customer, and that's potentially an unfair term. The third point is the sale of the loans to the vulture funds. Ed Honohan has just mentioned there that depriving the financial system of capital, such as Apple funds, means that banks cannot lend money. So if you think of a ratio of about 12.5 and you multiply the Apple figure by 13 by 12.5, you come up with about 160 billion that should be available to people who want to borrow money to buy houses. In Ireland, we've done something very different. What we've said is we're not going to put more money into banks as such. What we are going to do is sell loans to the vulture funds. And when you sell loans to the vulture funds and you sell it at a discount, it means that the banks lose their capital. And when they lose their capital, you multiply that by 12.5 to determine how much the lending goes down. And as you can see, it's quite considerable. Vulture funds have made a huge profit on the discount. It means that banks have lost the same amount of money, and the banks have lost money, lost quite a lot of money, because they must multiply by 12.5 the amount of capital they lost, and therefore they must restrict lending. So rather doing what Ed Honohan has just suggested there, which is to put more money towards lending, Irish banks have done quite the opposite. They've lent money, rather they've given away money to vulture funds. They have effectively subsidised vulture funds. And as a result, their ability to lend is restricted. And Theo has emphasised the importance of that. His generation are now a generation of renters, because the government policy seems to be look after the vulture funds first, housing comes second. And this may explain why it's not really a supply crisis, but a government policy crisis that we're in the predicament that we have today. Yeah. Unfair terms legislation, from what I can understand, it is the judge himself who should raise these points. So a judge should, in theory, look at a facility letter and say there are a number of unfair terms in this particular contract, and these must be examined. And given that the banks have been attempting to push their own losses onto borrowers, they've simply said, we shouldn't have lent you this money. We've made a loss. We want to recover that loss from you. That's potentially an unfair term. The interest term is also potentially unfair. And yet the judges have an own motion obligation to raise this themselves if you, the lay litigant, have not raised it. Yet, how many judges have raised it? I think very few. So there's quite a lot of unfair terms legislation that should be examined. As I said, the principle, if the bank believe that they're entitled to the full principal, it means that they're entitled to the contributory losses that they have suffered. And there is case law on contributory negligence. The case law states that if the banks break the law and as a result suffer losses, it's the bank's problem. It's not necessarily the customer's problem. The topic of securitization has come up quite a lot. I'm just going to leave you with a very simple message here. After 2005, many banks securitized their loans, not necessarily to the vulture funds, but to other funds. And the rule with securitization is that in order for the securitization vehicle to get a good credit rating, they must be bankruptcy remote. In other words, if the originating bank goes bankrupt, the securitization firm automatically acquire the legal interest in the loan. What that simply means is if the commercial banks have lost the legal interest in the loans, they cannot sell that legal interest onto the vulture funds. This has not been examined. Vulture funds have sent people into the courts and have sworn affidavits to say they're the legal owners, but that's impossible if the originating bank was insolvent. And you saw from the previous slide that there was quite a lot of insolvency in Ireland. Bank of Ireland and AIB are mentioned here, and the ratio is well above 100%. The rule with securitization is you can sell the rights to cash flows to a third party. So a Bank of Ireland could sell to a third party the rights to receive the cash flow, but that third party will say, if you get into difficulty, we have the right to take over the legal interest. So it could be that the legal interest on those loans have transferred on the date that the bank got into difficulty, or even before, because they, strictly speaking, banks should produce proper accounts which explain their solvency position. And in 2005, they decided to stop doing that. And so from 2005 onwards, technically, the banks have lost the legal interest in the loans that they've sold to these securitizations. So the bank should be put in the witness box and asked, were you insolvent? They'll say no, because PwC and all these people said we're not. Then you ask, well, did you reveal all the losses that you suffered? Or was there any delay? And they have to say yes, because they admitted that at the bank inquiry. Therefore, their insolvency is in question. We don't have to prove insolvency. We just have to show that they have not proved themselves to be solvent. And as a result, they may have lost the legal interest in their loans. There have been a number of developments. First of all, we have some judges arguing that the summary procedure is unfair. So they more or less have set a precedent in court. You must go for plenary and you must bring the original bank to court as witness to confirm that they had the legal authority to sell the loans to the vulture funds. That this particular judge has confirmed that there is unfairness if a possession case is tried at summary level only. One point on the German judiciary system, Seamus May, who's with us today, and he represents the International Small Business Alliance, he made submissions to the Law Reform Commission and has highlighted the fact that a lay litigant in Ireland doesn't stand a chance. There's inequity of arms, or whatever you want to call it. In Germany, they have recognised that, and they have referred it to some European court. The question is Ireland different from Germany? Is Ireland's judicial system better than the German system, so that we don't have to refer to the European court the fact that there is unfairness? And the answer is, I doubt it. I doubt you would argue that the Irish judicial system is fair. This is why, if you do go to court as a lay litigant, you must insist on a plenary hearing, not a summary hearing. You must insist that the original bank, not the vulture fund, the original bank turns up in court and explains, or rather even swears, that there are no unfair terms in the loan contract. And I think they will have difficulty doing that. Anna Kavanagh, who is with us today, she represents the mothers who are going to court at the risk of having their children taken away from them. And she has complained about the in-camera ruling. She has said it's quite unfair. And it is, if you think about it. I think there was an article in the Mail last Sunday which emphasised how unfair it is. Mothers basically are not allowed sometimes to give evidence. I'm guessing now, but sometimes to give evidence, and sometimes they're taken away from the court while a decision is made in camera. The in-camera rule not only affects the breaking up of families, but it also affects family homes. Back in 2010, AIB wanted to raise funds, but they did not want to reveal how insolvent they were. They ended up raising funds, and it was approved through an in-camera hearing. From what I can remember, 2 Irish Times journalists were asked to leave. They did not want this reported. Now, you might say that it was necessary at the time because it was an emergency situation and very urgent, but it doesn't. I don't think the rule, the legislation at the time allows banks to deceive in the way that they have done. I won't say it's a criminal act, but deception with a view to raising funds is certainly very questionable. They do have questions to answer. If that ruling has not taken place in camera, my belief is that AIB would have had to admit that they were in deep trouble and they were trying to raise money. And they would have had to say to the pension fund or whoever put the money in, okay, our published accounts are solvent, we look good. In reality, this isn't a liquidity crisis, this is a solvency crisis. We've lent too much money, we had very little lending criteria, therefore we lost a fortune, and yet we're insolvent and asking you to raise money. Now, what happened since the 2010 secret bailout, is that AIB and Bank of Ireland went to the general public and organised rights issues to try and raise money. and those rights issues went south. Anyone who got involved in those rights issues lost money. Why? Because the money was used to cover up losses and not to invest in assets which were going to generate profits. I'll be very quick to one. We have made progress. I want to end on a slightly positive note. The land registry, as I pointed out in the past, have said, not so much the land registry, but the vulture funds have said our name is on the land registry. That is conclusive proof that we own the asset, and it's conclusive proof that we're entitled to take the defaulting debtor to court. That has changed now. The Fannin judgment may have erupted. It was quite a recent judgment, and I think it erupted because of activity of a few people who put pressure on the land registry, and I think, Ed, you emphasised this as well. And we now have a situation where the judges won't rely exclusively on land registry records to prove that you own the assets. Also a development, if the land registry can't rely on if the vulture funds can't rely on land registry documents, they have chosen to use redacted contracts. This again has been challenged in case law. They can't rely on redacted documents. They must disclose the documents in full. And the argument you put forward there is when the banks lent money sold money to the vulture funds, they insisted, the vulture funds would have insisted that the normal lending criteria would have applied. And between 2004 and 2012, normal lending criteria did not apply. So there is a question whether the legal interest did actually transfer to the vulture funds.
Yeah.